chairperson.
Good.
Today is Mr. Koko.
Yes, hopefully his last appearance.
Please, Chair.
Good morning, Mr. Koko.
Good morning, Chair.
Thank you. Okay, Registrar, please administer the oath of affirmation again.
Please state your full names for the record.
Matshela Moses Koko.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath binding on your conscience?
Yes.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Yes.
He is represented as before, I assume?
Yes. Yes.
Yes. Thank you. Okay, continue.
Chair, I have a question of clarity, if I can
Yes.
ask before we go into the details.
Yeah.
I read in the website that the President of the Republic will be coming.
Yes.
I made statement in December 2020, and I said that Mr. Ramaphosa interfered and instructed the board of Eskom that was yet to meet to dismiss me.
Yes.
And I've mentioned the names of the former deputy minister and the former acting DG. And I just want to find out if Mr. Ramaphosa has been served with a 3.3 notice like all of us who's been served. Because I really want to know, why did Mr. Ramaphosa interfere in the affairs of Eskom by instructing the board of Eskom that was yet to meet to dismiss me? Then the instruction that the Labour Court found to be unlawful. And the consequences of that was in the CSIR report that just after I left for between 2018 and 2020, 266 billion rands was lost as a result of load shedding that occurred after I left. So I really want to know, and if the public are not interested in knowing, I really want to know. I will not rest peacefully until I know, why did the Deputy President of the Republic interfere in the affairs of Eskom to instruct the board that was yet to meet to dismiss me. I now know, based on the video affidavit and the testimony of Ms. Brown, that 3 of those board members were not even vetted as they should be vetted. So I look forward to Mr. Ramaphosa coming here. I hope you've served him with 3.3 notices. I looked at the documents that were sent to me last night. They were voluminous. I did not see a statement from the former deputy minister that I've mentioned. I'm not sure if he's been served with 3.3 notices yet. I've not seen the statement of
You said deputy minister, you meant deputy president or deputy minister?
I have not seen the statement of the deputy minister who phoned me and told me that the president will be. I thought that would be of interest to the commission.
Yes.
I also thought that it would be of interest to the commission that the DG who called me and told me that the president will be dismissing me. I did not see that statement. I did not see the statement of the deputy president, and I thought I humbly seek a clarity from you on what's going to happen.
No, I can tell you, I can't tell you for sure whether your statement implicating or to the effect that the current president issued an instruction, whether it was served, but Mr. Slega will be able to say that, but I can assure you that I too am interested in what the president has to say about your evidence in that regard. And he certainly should be questioned on that. The legal team is preparing on such matters, but Mr. Slega should be able to respond to whether or not a Rule 33 notice was issued, and the issue of a statement from the Deputy Minister as well as from the DG, you are right, those would be important. Of course, if the President were to admit that he made the statement or issued or made the statement that you attribute to him based on what you were told, then the need for their statements would fall away. But there is no reason why attempts should not be made to obtain affidavits from the Deputy Minister and from the DG or acting DG.
Thank you very much, sir.
Yeah, thank you. Mr. Selega, do you want to say something?
Yes. Part of the transcript of Mr. Koko was given to the President when we provided him with the equivalent of a Rule 3.3, which is a request for information, and we gave him documentation from Mr. Molefe's testimony and from Mr. Koko. Because I think in the case of Mr. Koko, that averment was made orally but not in the affidavit, as I recall, that he had instructed somebody to have you suspended.
Chair, my statement is very detailed in it. All what I did not do in the statement was to mention his name.
Yes.
Yes, but you had mentioned his name in your labor court application papers, is it?
We've mentioned the presidency.
Or you didn't mention that, you just said presidency?
We just said the presidency.
Oh, okay, all right.
Yeah. But we've provided the transcript, and the President or the Presidency is preparing an affidavit, Mr. Koko. They have undertaken to provide the Commission with an affidavit.
Yeah.
On the Deputy Minister and the DG, I do not have recollection, so I think you will have to help me with the names.
Deputy Minister Martins and the DTG is Makhola Mokokolo.
You want to just give the spelling for the purpose of transcript for the DTG?
Chair, I will do it. I can't spell it now. I'll do it during break.
Okay, all right.
Otherwise, I'm going to make errors. Chair.
Okay, all right, okay.
Is it?
And you say Deputy Minister Martins, is that the one who was Minister of Transport at some stage?
Correct. I think it's either Martin Dikobe or Dikobe.
Oh, no, that would be somebody.
It's either
Okay, but they can check. Yeah.
Dikobe Martins, I think.
Okay,
Yes, but he was the Minister of Transport before.
at some stage, okay.
He was a Minister of Transport before.
Okay, all right.
Okay. The spelling for the DG, if it is Mokokolo, I have it as Mokgokolo.
That sounds right, Mr. That sounds right. Yes.
Okay, all right.
I always confuse them with Matsi. That's why I don't want to.
Okay.
Yeah, okay, all right.
Yes.
All right, let's continue.
We can start.
Yeah.
Mr. Koko, let's start where we ended so that we can close that part. And that's the part regarding the emails to Info Portal, which you found in Eskom Bundle 18. Eskom Bundle 18, bracket B. So we hope to cover or to finalize on that.
Just I want to see bundle A in A.
18B. So, Chairperson, just by way of introduction, we hope to finalize on this very aspect, and then we go into the transactions, which involves McKinsey Trillion. I think we will start there before we go to get transactions, if we manage to get that far.
Yeah, okay, well.
I've got it, Mr. Slay.
Yes, thank you. Page 1018. 1018. So is those emails you sent to Info Portal from the 20th July 2015 on page 1018?
I've got it, Chair.
Yes, to page 1088. Remember your explanation to the chairperson was that every time you sent these emails, you would have a meeting with Dr. Ngubane and Ms. Daniels to talk about the document attached to the email. Now, Ms. Daniels has denied orally during her testimony having given you this email address as the email address of Dr. Ngubane, and also denied in her last appearance further that she had meetings with you and Dr. Ngubane after the exchange of, or in relation to the documentation exchanged in these emails. And you had also indicated that you would like to have an opportunity to explain to the chairperson each of these documents. My question to you is, can you explain to the chairperson, insofar as you refer to meetings with Dr. Ngubane? Let's start with the first email, which is internal consulting directive, and the documentation follows thereafter. What meeting would you have had with Dr. Ngubane, and what is it that you would have discussed with him in regard to the document attached here?
Excellent. So, Chair, the document, and the first document is on page 1019. Is that correct?
Yes, yeah.
Right.
1019, yeah.
So, Chair, this is quite an interesting part, and I'm glad we are going through it. The National Treasury has got a directive on the use of consultants. Not only does it have a directive on the use and how you appoint the consultants, but it also prescribes the fees for the consultants. The document you see on 1019 gives effect to the National Treasury Directive. It's an internal Eskom document. What Eskom wanted to do in my absence while I was on leave was to contract with McKinsey on the risk basis. That was wrong. National Treasury does not allow that. And the document you see there that gives effect clearly says so. And the only way that the board of Eskom could do that on the basis of a resolution they took while I was on suspension on the 6th of July 2015 was to go to National Treasury and to ask National Treasury for a deviation. But it could not proceed as if there was no National Treasury Directive and as if there was no internal Eskom procedure that gives effect to that. And that discussion I had with both Ms. Daniels and both Dr. Ngubane. I have read the supplementary affidavit of Dr. Ngubane on that, and I have a lot to say about it, and if I'm allowed, I will do that. But that's the basis of this discussion. The board of Eskom could not, on the 6th of July, have approved a sole source motivation that is not consistent with the National Treasury Regulation, that is not given, that has a document internally to Eskom that gives effect to it.
Well, this may be quite an important part of your explanation about these discussions with Dr. Ngubane and Ms. Daniels about these emails. So I just want you to take it step by step. First, You say the document at page 1019 is what? Is a directive
No, it's
from
not a,
Eskom
yes,
on directive for the implementation of the National Treasury Cost Containment Instruction and Government Gazette. Now, on page 1019, we've got the document and identifier, alternative reference, area of responsibility, Eskom, or area of applicability, Eskom Group, functional area, finance revision 1, total pages 13, next a review date, July 2015, disclosure classification. And then there is compiler and functional responsibility and authorized by at the end. Now, the actual directive, is it the document that starts at page 1020?
yeah, that's correct, Chair.
Okay, does it have 13 pages? I just want to see whether
It's got 13 pages, 13.
1-3.
13.
Okay, so that's in line with what is reflected at page 1019.
That's
to say
correct.
that. So, and this particular document is an Eskom document,
Correct, Chair.
but it's an Eskom document that seeks to give effect to a National Treasury instruction, is that right?
That's correct, Chair.
Yes, and the National Treasury instruction was to what effect?
The National Treasury instruction, first, National Treasury had a view, which I agreed with, that the state-owned enterprises should not unnecessarily rely on consultants when they can do the work themselves.
Yes.
And you will see, if we go into the detail, at that point, Eskom was spending close to R1 billion
On consultants.
on consultants.
That's quite a high amount.
Right. So National Treasury's scheme framework was make it a bit difficult for state-owned companies to arbitrarily appoint.
There had to be good reasons.
There had to be good reasons. That's one. But not two is that whenever you appoint consultants for good reasons, there has to be
A process.
first a process, and that process must include internal capacitation
Yes. For future.
for future.
Yes.
For future work.
Yes.
But thirdly, it was very prescriptive on how you compensate on the fees that these consultants must be paid. That's a nutshell.
Now, do we have that national treasury instruction in the bundle, or do we not have?
I have not seen it. I don't think
We
we
have
have
not
it.
seen it. Do we have it, Mr. Selega?
I don't think we have that specific one, Chair.
Okay, all right.
I don't think you have it. I've not seen it.
It would be good to have it. I assume if it's a big document, we can extract
Yes,
just
the
the
relevant
relevant
portions.
pages. Yeah. If arrangements can be made for us to find that. So I guess part of the point you are making is that the type of issue that this related to, because the email at page 1018 suggests that if your evidence is correct, suggests that you sent this document to Dr. Nkubane.
Correct.
So the point you are making is the type of issue that you wanted to raise would be the type of issue that's legitimate to raise with the chairperson of the board.
Most certainly. And,
Yes.
there's a step forward to it. If there is a third party who stands to get a competitive advantage, this document will not serve that purpose. Because this document will say to the third party, you stand no chance.
Yeah, okay. But I don't know whether you had completed your explanation.
I've completed my explanation on this document.
Mr. Selega?
Yes, thank you, Chair. Mr. Koko, you also mentioned...
I guess that you have completed your explanation up to a certain point. What would remain is to say, tell us about the content of the discussion at the meeting where this document was discussed, in the discussion involving you, Dr. Ngubane, and Ms. Daniels.
Most certainly, there's two explanations I still need
Yes.
to. There's two explanations I still need to give.
Yeah.
One is exactly that, and
Yeah.
I made a vehemence previously that Dr. Ngubane, when it comes to processes, was a better version of Zola Mr. Tsotsi. Most often than not, Mr. Ngubane would act out of ignorance. But once you put the facts on the table,
advised him.
once you advise him and you put the facts on the table, I can tell you he even becomes stubborn because he now knows. That's the Dr. Ngubane I know. Dr. Zola Tsotsi is different. When you tell him the facts, he put a trip, he wants to kill you. So there's a difference. So Mr. Ngubane had a posture. He sits and he doesn't talk too much in the meeting. And once he sees it,
Once he sees the point you're making.
once he sees the point you're making, he, in a very dictatorial fashion,
Yeah.
says, "Okay, I understand. That's what we're doing."
Yeah. Yeah.
So
No
that's-
further discussion.
No further discussion. That's how he
Yeah.
does not leave room.
But he would listen to hear what somebody else who might think differently has to say.
Yes.
Yes,
And he
okay.
talk very clearly. And Mr. Ngubane, and those who know Dr. Ngubane, both at the board meetings and one-on-one, all his meetings are very short. So he understood my point. He took my point. And I remember him, Dr. Ngubane, telling Ms. Daniels, and this is what I want to go back to his statement, saying, we must never make a mistake of going ahead without National Treasury's deviation, or we don't do this. That was his last words. I remember them very clearly. I was very happy because this was going to make, this transaction was going to break the relationship between me and him and the board.
Okay, all right.
Yeah.
Mr. Selega?
Thank you, Chair. Mr. Koko, what is it that you were talking about with Mr. Ngubane in regard to this document? What did you say you were talking with him?
The board took a resolution in my absence for a risk-based decision. That decision,
In relation to McKinsey?
in relation to McKinsey, we called it Top Engineers Program. That decision was not only inconsistent with the National Treasury's practice note, but was also against the Eskom directive. So this directive.
It's directive.
Yes.
Yeah.
So ordinarily, if properly advised, the board would have said, go sort this matter out first with the National Treasury before you come to us. The board would not say, we give you a mandate to negotiate without having assurance that indeed National Treasury will indulge them. And that's a discussion that I had with the chairman.
Yes. So you raised this issue. What was his response and what was Ms. Daniels' response at the meeting where you had this document before all the three of you?
Like I said, Mr. Ngubane talks very little. He listens a lot. And he got the message, he got it quickly. And his response was, okay, this is what we're doing. Ms. Daniels, just make sure that we either get a deviation or we don't do this at all.
So at the time that you sent him this document, they had not approached, Eskom had not approached National Treasury for a deviation, or they had already done so, but the outcome had not been communicated.
They had not done it.
Or they had not done it.
Correct.
But had the Eskom board said to the management, negotiate with McKinsey, or what had it said before you raised this issue?
Well, there was a resolution that was taken in my absence when I was on suspension. The suspension that I conveniently arranged so that they can make this decision. Now, that's how ridiculous it is. The narrative is that my suspension was a sham so that certain transactions can happen. So McKinsey is one of them. So I participated in a conspiracy and a sham suspension so that the board of Eskom can take a resolution to negotiate with McKinsey on a risk basis. And they did that without having been to National Treasury. And the intention was that while you're negotiating with McKinsey, go and talk to the National Treasury. Go and talk to National Treasury.
Let's take it step by step. Do you, by any chance, recall what date the resolution was?
6 July 2015.
6 July 2015.
I can't forget it, Chair, because the High Court erroneously concluded
that you were at work.
That I was in charge of it.
Yeah, okay. And you returned on the 20th of July,
I
is that
returned on
right?
the 20th, yes.
Yes. So what you are saying is, on the 6th of July, while you were on suspension, you later found that the board had made a resolution to the effect that the executives should negotiate with McKinsey with a view to, or in regard to the top engineers program. Is that right?
That's correct.
Yes. And when you came back, you realized that this was in breach of not only the National Treasury Instruction Note, but also of this directive of Eskom, and you decided to bring this to the attention of Dr. Ngubane.
That's correct.
And you had a meeting, and in that meeting where this issue was discussed, Dr. Ngubane saw your point and instructed Ms. Daniels that she should make sure that National Treasury was approached for a deviation, or otherwise, if National Treasury did not provide a deviation, the program should not be pursued. Is that right?
That's correct, Chair.
Okay, all right. Mr. Selega?
Thank you, Chair. Mr. Koko, you would recall the
Chair,
evidence.
let me, before you go there, you'll see, and we'll come back to it, you will see this transaction comes back again on the 6th of October. And that's a document that I signed to the board, which again makes a reference to National Treasury compliance.
Is that the feedback report?
That's the feedback report.
Yeah. So while we are here, we should make a distinction between the corporate plan and the master service agreement.
That's a very good point, Chair. So again, I guess Mr. Seleke will lead evidence on the master service, on the business plan. And the business plan is often confused with the services level agreement. And my name gets dragged into that, and I get corrupted in between. And I think that's what the judges of the North High Court did as well. So when the need arose, pursuant to a NERSA decision of the 29th of June, mark that date, Chair, we're going to come back to it, on the 29th of June, and we needed a financial plan and a business plan that is based on what we call a cost, a design to cost, as opposed to a cost-reflective business plan. I listened to the testimony of Ms. Singh, and I don't know why he did not explain this simple concept to you. All along, the business plan of Eskom was based on a cost-reflective tariff. So we have a wishful list. That wishful list leads to a cost, and we then take that cost, we put it in a business plan, then we go to the consumer, we recover the cost. The decision of NERSA on the MYP, what we call multi-year price determination 3, we call it, in short, we call it MYPD 3. We applied for just over R1 trillion revenue for 5 years, and they gave us 883 billion rands. We were short 225 billion rands. So the business plan that was there on the table, that the very competent Eskom executive allegedly put together, was 225 billion rand short. So we needed to restructure our operations and have a business plan that is based on the cost that we have. So designed to cost. And Mr. Singh and I agreed that we must approach McKinsey to put a business plan that was based on the cost that we have, not on the wishful idea that one day NERSA will change their minds and give us 225 billion rands that we do not have. So we approached McKinsey. McKinsey had been historically working on a design to cost model. The reason why I took a decision, and it was my decision, not to use the MSA was because and you'll see that a lot of emails when I send the teams, what is the feedback on the negotiations with the McKinsey? And one thing that continuously came out, even though they did not even say it expressly, because I think they realized, in my view, in hindsight, there was trouble brewing, is that National Treasury is not going to give them a leeway to contract on a risk-based approach. So I took a decision that the scope for the business plan that I authorized from the 29th of September 2015 will not be based on risk-based, will be based on a fee that is approved by National Treasury. So that's the difference. And it's quite a simple concept, and I don't understand why both Mr. Singh and Mr. Seleka struggled to explain this to you.
Chair, I don't want to be personal.
Yeah.
But I don't have to explain anything to the chairperson. You as witnesses have to give evidence to the chairperson.
I'm here to do that, Chair.
So your explanation relates to the corporate plan. Is that right? The explanation you've just given to the chairperson.
Correct.
So you and Mr. Singh, you say, agreed to approach McKinsey in order for McKinsey to provide services in respect of what you say is the business plan.
Correct. And the business plan, let's complete the sentence, sir. The business plan and the financial plan, that will be based on the design to cost, not a cost reflective.
So, and you're referring to the date of the 29th of September 2015. I think that's the date when you signed, what, the letter of acceptance?
That's the date that I signed. And Chair, while we are on this, that's a date that I did not only sign the letter of notification for the business plan, but I put the contract into effect. Now, one of the things that I'm struggling with is that, let me put it this way. Chairman, Eskom operates within a framework. And that framework is the Constitution of the Republic, is PFMA, Public Finance Management Act, that gives effect to the Constitution, It's the delegations of authority, and it's a document which we refer to as 1032, the procurement and finance procurement procedure. I'm going to spend a lot of time on it today.
Is that a document different from the one that Mr. Singh was telling us about?
It's the same
on
document.
Friday, namely 10, but I think he was saying 1034.
1034.
Correct.
1034.
He's right, you are wrong.
I'm wrong.
Okay.
1034. And then what we call a materiality framework. So it's a PFMA delegation of authority 1032 materiality framework. There are other procedures. In my case, I will mention another one on information security because we're dealing with emails. Chairman, if you don't like the taste of that framework, don't prejudice me. I have listened to many submissions, and I get a feeling that you may not like that framework. So
You must use this opportunity to make me like it.
yes. So all what I'm saying is there is a framework in Eskom, and I am consistently going to tell you that I operated within that framework in Eskom, and I made prudent decisions that are in the interest of Eskom, and you can
Based on that framework.
based on that framework,
Yeah.
and if you conclude that there was state capture at Eskom, the difficulty you will have is that since 2002, I've told you before, and I'll tell you again, that the results in my time were the best.
Well, I just want to say that even though I'm saying to you, you must use the opportunity to make me like it, but I'm actually not meaning that in a serious way. Whatever framework was there, one has got to look at it, and it's not a question of whether I like it or not. I must just see what it means, understand how it works. I'm not running Eskom, and I wasn't running Eskom. Those who put it together, rightly or wrongly, may have thought that it was appropriate to put in place. So obviously, if there are issues that I think arise or questions that I have about it, obviously I would raise those. But just on a serious note, it's neither here nor there whether I like it or not. But
Sure.
you must make sure that you feel free to put your case properly.
Chair, thank you very much. And after I've done that, you may still not like it, but it's within your scope to make a recommendation to the president to change that.
But I won't decide according to whether I like it or not.
Yeah, but that's fine, Chair. While we're on that, Chair, I'm saying my signature of the letter of notification and acceptance by McKinsey on the 29th of September 2015 put the contract in place. Whether the contract was signed or not, that's the framework of Eskom. And while we are there, Chairman, I would like to take you to that document.
Let's see what Mr. Selega's plan is, because he may have intended that to deal with it later. I don't want us to upset his plans. Is it fine that he goes to it now, or?
I think it's still fine.
Okay,
It
let's
will
do
help
that
us,
then. Okay,
maybe it will help us
expedite.
expedite
Yeah,
the issues.
okay, all right.
Let's go to MK49.
Yeah.
I'm sorry. I see Mr. Berry, your
Yes,
mic
I just
is
want
on.
to give the reference to you, sir.
Yes, okay, sure.
It's
Let's go.
Eskom bundle 15
Yes,
at page 594.
thank you. And I think you can then switch off that mic, Mr. Berry. I think you can then switch off that mic, yeah.
Chairman, I'm going to take you to, and we'll come back more often to this document, 678.
Okay, I'm at 594. Should I go to another page?
Yes, please go to bundle 15, 678.
Yes.
Chairman, there's a chapter that talks about administration of awarded contracts.
Hang on 1 second. I just want to make sure we are on the same page. Now, when we come to this document, what's the topic that we are dealing with? Mr. Slager, Mr.
No, because I
Koko?
thought Mr.
Can I explain to you?
Yeah.
I signed the contract, the letter of award to Mackenzie, pursuant to a full board, and Chair, in my statement, I say board tender committee. I've read the statement of Mr. Anosh Singh, and he corrects me that it was actually not the board tender committee, it was a full board, and I accept. I think he's right, I was mistaken. So the board approved the award on a fixed fee basis for 102 million rands to Mackenzie for the business plan. In terms of the Eskom framework, 32-1034, you have to notify the supplier whose contract has been approved by the authority. And that notification is binding on Eskom. This is why
That is now notifying them of the fact that the fee will be fixed.
No, that's notifying them that a board tender committee in Eskom has approved the award of a contract to you.
Okay, obviously.
Under these terms and conditions.
Which include the fixed.
Which include the fixed fee.
Okay, okay, yes.
And once you notify it and they accept it, it's binding on Eskom.
Yeah, okay.
It's a contract. But
Yes.
remember, at that point, the contract is not signed.
Yes, yes. Oh, that's the point that you said you thought I didn't like.
Yes.
Okay, all
Yes.
right. Okay.
Now, Chair, there's a point that you had, which I'll mention, but Eskom is going to stop functioning if that is not the case. There are many contracts today in Eskom that I know of, whose contracts have not been signed, but the letter of award has been awarded. What you cannot do, and that's a point that I thought Mr. Senator was making, you cannot pay a supplier without a signed contract.
Yes.
Chair, I think the point of the exercise was to get the passage in the procedure, and that is at page 678, 15678, clause 3.4.8.1.
Yes.
Oh, you
Can
wanted
I-
to read
can
that
I
into
read
the
it, Chair?
record? Yeah,
Yes.
do that.
Once approval has been given to the award of the contract to the successful supplier, the procurement practitioner notifies the successful supplier of the acceptance of his tender. The procurement practitioner must ensure that this notification is received by the successful supplier, because notification of acceptance will become legally binding upon Eskom. And that's the point I'm making.
Yes, just complete the the clause, and then we can talk about it.
Email notification will be subject to Electronic Communication and Transaction Act.
Yeah, okay. Let's, I think it's important that it was important that you refer to this passage, this clause. But let's talk about the issue that you say I didn't like. One, not that I didn't like it, but two, you may recall that in the context of Mr. Singh's evidence, what he was saying was, in effect, look, even though there might not have been a formal contract or agreement that had been signed by both parties, there had been an offer and acceptance. And he was saying, based on his recollection of commercial law that he did many years ago, that should be enough, okay? So what I was saying to him, well, one, his recollection of the law might be based on many years that have lapsed, but in principle, he is correct that if there is an offer and an acceptance, there's an agreement, okay? That's a general principle. But what I was raising with him was whether the position is not that in the context of SOEs, there has to be a formal written contract in addition to whatever correspondence may have been exchanged, which indicates that the parties agree. That's the point I was making, because I've been made to believe that with regard to various SOEs, you might get notification that you have been awarded the tender, but until there is a proper formal agreement, they would not regard the two parties as already having an agreement. Now, if you say to me that was not the position at Eskom, that might be different. So I was simply raising something based on what my understanding is of the attitude of SOEs. So I just wanted to make sure that you understand the context in which I raised the issue. So it wasn't whether I like it or not.
Chair, I accept that. But
Yeah.
Can I also assist you
Yeah.
on that part? Because I think this is very, very important. On the same page, it's a instruction that talks to signing of contracts.
Sorry?
On the same page,
Yeah.
paragraph 3.4.8.3
Signing the contract, yes.
deals with signing contracts.
Yes.
But it does more than that.
Yes.
It tells you when you can assume, it tells you when you can resume work
Yeah.
or not.
Yes.
I would like to read it into the records too.
Yes, no, that's fine. But I must say to you that you are right to point out clause 3.4.8.1, because as you said, it specifically says the procurement practitioner must ensure that this notification is received by the successful supplier, because notification of acceptance will become binding upon Eskom.
Yes.
So in other words, it has got legal consequences.
Yes.
Yes. So did you say you want to deal
Yes.
with 3.4.8.3 as well?
Yes, and that notwithstanding, Eskom
Still expects that there would be a contract.
Eskom still expects that there will be a contract, and that contract must happen preferably before the work starts.
Yes, okay.
That's
Okay. Is the position, as you understand it, that preferably the formal contract must be concluded before the work starts. But if, for whatever reason, work were to start without the formal contract being concluded, as far as you know, Eskom would regard the two parties as contractually bound in a contract.
Exactly, Chair.
Yes, that's the point you make.
Exactly.
Yeah.
And what we will do, in that case,
Yes.
we will discipline
Yeah.
the procurement practitioner.
Yes, but as far as the third party, the
We will not,
supplier
we
is
will not
concerned,
interfere with the third party.
Yes, yes. No, that's important to that explanation is important. As I say, my understanding in terms of evidence that I've had in regard to some SOEs, it might not be all of them, is different. But it may be that it's factually different. But what you are telling me about is what happened in Eskom, what the documents say, and what the practice was.
Yes.
Yeah.
And this procedure goes a step further, Chair. It says once you have notified the successful supplier of the award and he's accepted and there's a binding contract, it's binding, but there is no contract as yet, and you want to start working now because
Of agency.
of agency. The general manager procurement must authorize that.
Yeah. I assume that in a case where you have complied with clause 3.4.8.1 and you comply with clause 3.4.8.3, the conclusion of a formal contract,
Yes.
the terms and conditions that find their way into the formal contract would be contained already in the exchanges that have happened before.
Most certainly, Chair.
And in other words, from the time you send the notification contemplated in clause 3.4.8.1 to the time of the conclusion of the formal contract, there are not going to be negotiations of terms, because when you accepted, the terms were settled.
Chairman, once I give you a letter of award
Yeah,
and the terms and conditions that comes with it, negotiations are complete.
yeah.
So, and Eskom uses, and this is another term this is another part that I thought you've got a misunderstanding about Eskom. Eskom uses standard conditions of contracts. None of us is allowed to deviate. And if you want a bespoke contract, you have to. It's a onerous, difficult process that has to go through commercial, and we will also go through the delegations of authority. So the letter of award will say standard contracts, standard terms, apply, and it will also add additional conditions that the board approved. That's it. No more negotiations.
Would it be correct to say this procedure at Eskom, which you are telling me about, which includes clause 3.4.8.1 and clause 3.4.8.3, actually means that the conclusion of the formal contract is really for convenience, so that you have all the terms in one document.
Exactly, Chair.
Otherwise, the contract, the terms and conditions have already been agreed and settled when the notice of acceptance is sent to the supplier.
Of course, Chair, and it will be disaster if that's not the case, because
Yeah.
then the board does not know what they're approving.
Yes.
Then the cost is not fixed.
Yes. Okay, no, I understand. Okay.
Thank you,
Mr.
Chair.
Silega?
Okay, I think it wasn't particularly a good idea to concede to take this route, but
Well, if you were saying, if if you were saying, Mr. Koko, that if you were saying that you didn't know why Mr. Selega didn't explain this, is not Eskom, so you need somebody from Eskom to know what the practice was. But Mr. Singh, I would have thought, you know, would have explained it, but maybe he was still going to explain it.
Yeah. There's another part, Chair, that we will come to, and I'll let Mr. Seleka deal with
Seleka.
it. Mr. Seleka, I sincerely apologize. Deal with it at the right time when he's ready. It's the issue that the contract was not signed by me, but I was a delegated person.
Yes, yes.
That's another part that I really
That you want to explain.
explain. And I said to my counsel, if I get under
Forget.
pressure and forget it, he must
Remind you.
remind me.
No, that's fine, that's fine.
Okay. Mr. Koko, let's just finalize on this very aspect where you refer us to page 678 in Eskom bundle 15.
Do you want me to go back there?
Yes, let's just finalize on it.
6, 7, 8.
Yes. So we are dealing with, and I want us to be clear, we are dealing with here with the corporate plan. Is that right?
That's correct.
With the letter that is it a letter of acceptance on the 29th of September 2015?
That's correct, Mr. Six.
Yes.
Now, just
Now-
to make, I'm sorry, Mr. Selega. You spoke about the business plan.
Yes.
Was the business plan part of the corporate plan?
Oh, so the corporate plan, business plan,
One and the same
is
thing.
one and the same. Sure.
Okay, all right.
Yes.
Okay, I just want to make sure, because if we use different terms, whoever reads might think it's different matters. Okay, all right.
Mr. Seleka, I'm there.
You are there, yes.
Okay.
So I didn't quite get your explanation, but I thought the paragraphs 3.4.8.2, you could also have drawn it to the chairperson's attention. Because the second paragraph after the first one, which says procurement practitioner is responsible for compilation and administration finalization of the contract / order. The next one says, if a contract, NEC, has been used, the procurement practitioner, together with the cross-functional team, ensures that the contract documents are correct and complete with all drawings and specifications and included as part of the contract. So I thought you would also explain that part to the chairperson. And it goes on, the last sentence in that paragraph says the procurement practitioner arranges for the printing of the contract for purposes of signature. Let me go on to the next item 3.4.8.3, which is signing the contract. It says once the contract is printed, the procurement practitioner takes the contract to the official and authorized Eskom signatory as nominated by the delegated approval authority to sign the contract on Eskom's behalf. The nomination is done in terms of Eskom's delegation of signing authority as set out in Appendix B. It is the responsibility of the procurement practitioner to ensure that the contract is signed by the duly authorized delegates of Eskom and the supplier before order placement against the contract. In other words, orders cannot be executed against a contract where the contract has not been signed by the parties. And any orders placed against the contract in the absence of contract signature may place Eskom at legal risk in the event of breach of contract, a claim against the contract, or a dispute with the supplier. To the extent that orders may have to be placed before contract signature, consent must be obtained in writing from the relevant GM, commercial, or his or her nominated representative, or the DE, primary energy, or his or her nominated representative. So I thought that too.
Are you making any point different from the points he made? Because my understanding I'm not understanding this to be
Yeah, Chair, I
any
think it's
different
making,
from what
it's
you
making the
said.
same point that I made.
Yeah.
It's exactly
Is
what
it
I made.
exactly the same?
Exactly
Which
the
is,
point I made.
which is there must be a signing of a contract.
No, I said to you.
I'm sorry.
Yes.
Let's make sure so that we only spend time on it if there is confusion.
Yes, Chair.
Are you suggesting that your understanding is that the notification must happen after the contract has been signed, Mr. Selega?
No, Chair.
No, yeah, because his evidence is
Yes.
there comes a time in the process where notification has to be done
Yes.
under clause 3.4.8.1. And he says that notification happens at a time when there is no formal contract yet. But he says when that notification happens, then in law, I know he didn't say in law, but it amounts to saying that in law, there is a contract between Eskom and the supplier, and all the terms and conditions have been sorted out, otherwise there would be no approval and no notification. But he says, nevertheless, there must still be a formal contract. And that formal contract, the conclusion of that formal contract and its signing comes later. And he says, in response to my question, the terms and conditions that will be in that formal contract are the terms and conditions that had already been in place and had been agreed at the time of notification of, in terms of that. And he says, no work is supposed to be done by the supplier until the formal contract has been concluded.
Okay.
But if there are reasons of urgency that make it necessary that work be done before the formal contract is concluded, there is a process to be followed and authorization to be obtained. That's the sum total of his evidence. You agree?
Fully, Chair.
Yeah.
Yes, which must be in writing, as the paragraph says there, Chairperson. To the extent that the orders may have to be placed before contract signature, consent must be obtained in writing. And they specify the persons. Okay. So, Mr. Koko, I know you are dealing with the corporate plan as you have watched.
Are we done for now with this, with band 15, or will we need it later, or I must still have it?
Chairman,
No,
I can't
I
put my hand on it now, but maybe it is relevant in this context to record where that acceptance document is, the acceptance document of the 29th of September. Because my recollection, and I'm going to have difficulty to find it right now, is that it was accompanied by a contract document,
Yeah.
which was signed on behalf of McKinsey.
Yeah.
It was only much later signed by, I think, Mr.
No.
Mabelani on behalf of Eskom.
No,
So
that's
the
fine.
contract had in fact been finalized.
That's fine. Let's leave it to Mr. Selega as to when he wants to deal with that.
Yes.
I think the most important part was for Mr. Koko to explain what he has explained. And so what I'm asking now is whether...
I'm done with this document.
done with
I'll
this.
come back to it later.
Yes,
For now, you
please.
can remove it.
Okay, all right.
Unless
Mr. Selega, you
Mr.
agree?
Selega wants to deal with it.
Okay, all right. Thank you.
Yes, thank you, Chair. What's Mr. Kuku?
I see we are at 11:15. Maybe let's take the tea adjournment. And then when we come back, we can then continue.
Thank you, Chair.
We adjourn, we'll resume at 11:30.
So what is now the status seeing that this is apparently Mr. Koko's last day. Matshela, just remind me, where is that contract? Is that part of Singh's stuff? Where is that contract that is supposed to be signed by Matshela? Where is
1, 2, 3, 4, 5.
Okay, let's continue.
Thank you, Chair. Yeah. Mr. Koko, we were busy dealing then with the corporate plan. Let's see whether we can finish that so that we can go back to the emails to Info Portal. I would like us to go to Eskom Bundle 14, bracket C. Eskom Bundle 14, bracket C, page 877.82.1. 877.82.1. Go further, go further.
Chairman, we received a bundle electronically on Saturday, or yesterday. But that only goes to page 678, not to 817. It appears that there are annexes to this affidavit that we were not supplied with. Possibly before my friend goes in that direction, we would seek to have them supplied.
It might be something you want to deal with now or later, Mr. Selega.
Yeah. If my learned friend could indicate which affidavit is it referring to?
switch on your mic, Mr. Berry.
No,
There's an affidavit of Mr. Singh. I think it's a supplementary affidavit at page 768.
no,
And that's the last page in our bundle.
that's not the bundle I'm referring to.
You said bundle 14.
Yes,
Okay.
bracket C.
Okay, all right. Just before you proceed, Mr. Silega, Mr. Koko, I just want to have some confirmation from you of something that I believe you said about the clauses in that document that we were looking at earlier. You remember which clauses I'm talking about? Yeah.
Yes.
Did you say that what Eskom would not be permitted to do in the absence of a formal contract is payment, but the actual work can be done provided the relevant authorizations have been obtained and the notification has been given?
Correct, Chair. And this is very important, Chair, because I think we're going to come back to the invoicing and the payment. And I grew up in Eskom. I keep on saying Eskom is, my blood is blue. My association with Eskom is over 33 years. I may look young. There is a course we did, and we do everywhere. It's called Managing Contracts in SAP. It tells you exactly what to do to make a payment. So the contract manager will sign off what we call a completion certificate. And the completion certificate will either say goods have been received or work has been done, services has been done, and the contracts manager, authorizes that the job is done. Then there's an invoice. The invoice goes to the contracts manager. The only people who pay suppliers in Eskom is not Mr. Singh, it's not contract manager, it's shared services. So the shared services will receive the invoice. The first thing the finance person does, is that he checks if there's an order number. So if there's an invoice that is not accompanied by an order number, and we loosely call it in colloquial term at Eskom, a 4-5 number. So a contract, if you see the contract we discussed, is 4600529909, I think. It's a 46 number. You don't pay on a 46 number. You have to create a 4-5 number. So the invoice comes, the financial person checks if there's a 4-5 number. In a loose language in Eskom, when I say where is the 4-5 number, I'm asking you the question, is the order placed? Is the order signed? So there's a 4-5 number. Once there's a 4-5 number, so there's an invoice with a 4-5 number, then there must be what we call a goods received or services received in SAP. And the goods received and services received is done by the contract manager. We call it a three-way matching. So you cannot do a payment without a three-way matching. You're matching the invoice, you're matching the order, and whether the job has been done. And one of the frustrations that I have witnessed when I'm sitting at home is to see the focus on Koko, the focus on Mr. Singh. I call it Koko Hunt. Because the focus must be on the process. The process says there must be an order number. Was the order placed? And if the order is not placed, who did not place the order? Was the work done? Who signed the goods received, Chair? Somebody signs a completion certificate. Somebody put his neck on the block that the work was done.
Yes.
Who is that guy? That's a process.
Yeah.
And then somebody paid. You call it three-way matching.
I think
that must be, unless the person who did a completion certificate, the person who did goods received, the person who did payments comes to you and say, actually, I was given instruction by the orders above,
To go against the normal.
to go against the normal process.
Yeah.
Then it will make sense.
That's a different thing.
That's a different thing. But I don't see affidavits or statements of the
Yeah.
people in the process that says, I was given instructions to do this unlawful thing.
No, what you say is important. You see, Mr. Singh is still going to come back. He has not finished, but what I was hoping he was still going to do, and I don't know if I said he should do it, is not to just speak in general terms to say at Eskom there are processes and procedures, but to say here are the documents that outline who has the responsibility to do what in regard to payments. Here is a document that says this is the journey that leads to the actual payment. And during this journey, the following people have got the following roles. He hasn't done that, but he has mentioned in general, but I certainly will be interested in a document that indicates that, and it may well be that Mr. Selega knows that document is in one of these big bundles, but I'm interested in whether at Eskom, as I would expect, there was a document that says before payment is done, so and so should do this, so and so should do that, so and so should do that, and if one of these things have not been done, payment should not be made. And who the person is who must see to it that they have been done, I assume that the person who authorizes payment must satisfy himself or herself that all of that has been done. So that kind of document I'm interested in.
Chairman, that will help a great deal. It will help you get to the truth
Yes.
and stop the gossip. Can I summarize? In Eskom, you don't pay an invoice without an order. Without an order can only come from a 45 number. Somebody has to do goods received, and somebody, shared services, do the payment. I heard you asking too many questions that the CFO must authorize a billion rand payment. It's not there at Eskom. But Chair, please, Chair. The document you are looking for is called Managing Contracts in SAP.
Yeah.
That's a document you are looking for. It's got all the details of who must do what and when.
Yes.
And if that has not happened, that's a misconduct. If somebody comes to you and say it was a misconduct because the order above said I must override this, then you can hunt me or you can hunt somebody else.
Yeah, yeah. No, that's important. If we don't have that document, we should have. But it may well be that Mr. Singh was still to get it and give it to us, because certainly for his version, it's quite important. And it may well be that it's important for your version as well. I'm not sure, but certainly for his. Okay, all right. Let's continue.
Yes, Mr. Koko, I had referred to this bundle, but I'm reminded that you say, and sorry, I just need to get this out of the way because otherwise I forget it. You say you and Mr. Singh agreed to approach McKinsey in regard to the business plan. When Mr. Singh was here, he testified that when he wasn't satisfied with the funding plan that was prepared by Mr. Andre Pillay, he approached Eric Wood, Mr. Eric Wood or Dr. Eric Wood, to assist with that funding plan. Were you aware of that?
No. Chair, again, I'm terribly sorry I have to do this. The document that we took to the board was signed by Mr. Anosh Singh. There is a reason why he signs it. That reason is not arbitrary. He signs it because he is the user. The user in Eskom is a defined term, and is defined in Eskom procedures. To answer Mr. Selega's answer, can I take you to the user, why does he sign?
Yeah, that's fine.
MK49 once again.
Okay. Same bundle that we have in front of us.
Bundle 15.
Bundle 15.
Mr. Koko's.
Okay.
Chairman, I'm sorry I'm going to frustrate you with documents and references, but a lot of this noise is going to disappear because...
No, that's important, subject to simply saying that Mr. Selega must indicate where to do that at a particular time might disorganize his plans. But at some stage, those things must be done, particularly when people who are affected feel that they are important in order to put into the right perspective the points they want to make. What page did you say, Mr.?
Bundle 15, page 677.
Okay, just 1 second. So Mr. Selega, you will indicate if you'd like a particular point to be dealt with later, but otherwise,
Okay.
if Mr. Koko wishes to deal with a certain point at a certain time, that seems to be important, I would let him do it. Otherwise, we can always arrange that it be dealt with at a later stage.
Thank you.
Yeah, except that he's asked me a question, so I'm just answering.
No, I'm now talking in general for the future. I'm just simply saying, when you wish to make a certain point and refer to certain documents, I would allow you unless he indicates that he would like that to be dealt with later. Okay, I am there, Mr. Koko.
Paragraph 3.4.7.
Yes.
I will read it into the record. Since the transactions are based on an end user's...
I'm sorry. Did you say 3.4.7?
Certainly, 3.4.7.
Oh, okay. You didn't say you are skipping the first sentence, so I was...
Oh, yes,
you were saying since, and I was looking at once.
My fault, Chair.
Yeah, okay, all right. Second paragraph, so to speak.
Second paragraph, yes.
Okay.
Since the transactions are based on an end user's request and are paid for by the end user's cost center or project, the end user has the responsibility and authority to determine that Eskom's needs will be met before the recommendation is made to a delegated authority, or before an order stroke contract is placed, by providing his written consent through sign-off of the recommendations being presented to the procurement practitioner prior to the presented to the delegated authority. Now, the delegated authority this time was the board. The user is Mr. Singh, as a finance director.
Would the term user refer to the head under whom the project falls, for example?
Yes, so the user refers to, Eskom has got cost centers. A cost center is delegated a budget and the scope. He needs the work done. But he can't procure because procurement is a delegated function of procurement. So he then goes to commission and say, I have this need. The need is a business plan. The need is a corporate plan that must comply to the design to cost strategy. And later on, I will take you to the board minutes of the 22nd of 2015, my council has a document, and you'll see where the need arose. In implementing that need, we then approach McKinsey. But the scope can only be signed off by the person who's going to pay, because that person authorizes that I have the money. The money is budgeted for. The delegations of authority enjoins that you don't do any project that is not budgeted for. It's a requirement of the PFMA. But also the scope, only the user knows that. And this procedure says the user consents by signing the documents that goes to the delegated authority.
Is the user the head of the relevant cost center?
Correct, Chair.
So Mr. Singh would have been the head of the relevant cost center in this case?
Correct, sir.
Okay.
So the cost center that was used for the business plan would be Mr. Singh's cost center.
Okay, okay.
So he is the user.
Yes.
He decides the scope. He decides which professional he uses, who he approaches. I don't know that.
Now, when we're talking here about the corporate plan, which led to or will lead to the MSA, is that right?
No, Chair, and this
No.
is where the problem I have.
Yes, yes,
There's a very conceited approach to want to link the two.
yeah.
And
yeah.
the two are completely
Are
different.
separate.
Yes.
Okay.
The two
So
are completely
he is the head of the cost center insofar as the corporate plan relates to his center.
correct.
Yeah, okay, all right. Mr. Selega, I just want to make sure.
That's fine, Chair.
Yeah, okay.
Yeah, no, that's absolutely fine, because it has been clear in our minds, even with Mr. Singh, that the
Yeah.
two are different.
Yes,
Yeah.
okay.
But, okay, I think your answer to my question, Mr. Koko, because the question was, Mr. Singh, when he was here, he said he approached Dr. Eric Wood to assist with the funding plan. But you were saying you and him agreed to approach McKinsey. So I was just drawing to you the distinction between your version and his version, but your answer is you don't know. In regard to his version, you don't know.
I don't know who he approached.
Yes.
I don't know who he approached. I just know that, and I can tell you, Chair, that Mr. Singh and I think Mr. Mabilani, I am not sure, but I think he was there. We had a meeting with McKinsey, and we briefed them on our request
About the corporate plan.
about the corporate plan.
And is your understanding that that was the first entity that was approached about the corporate plan? When I say entity, somebody outside of Eskom. Or
In my view, it was the only entity
it was the only entity.
that I approached.
Yes.
That me and him approached.
Yes.
The rest,
Yeah,
I
it's his story.
have no
You don't know
knowledge of.
anything about it, the
Yes.
other things. Okay,
Yes.
all right, okay.
Isn't it that when you, sorry, because this issue is,
Well, Mr. Seleg, I'm sorry. It might be important to establish when it was, if it's possible, that approach in which Mr. Koko was present when they briefed McKinsey, when it was, because then one can check when it was that Mr. Singh talks about approaching trillion or regiments. Then we can see which one happened first.
Chair, I can assist.
Yeah.
Mr. Barrow, do you want to give the chair the board minutes of the 22nd of July?
which year?
Well, what we can do,
So
you can
the
mention
date-
them, and then I can get them later if
Okay,
necessary.
The date must have been between the 22nd of, after the 22nd of July to the 1st of August,
Okay, somewhere during that time.
during the time. And the reason for that is because the need was triggered, for the business plan, was triggered in the meeting of the board of the 22nd of July 2015.
Okay,
But the first proposal I got from McKinsey is dated the 1st of August 2015.
okay.
I have those board minutes available, supplied by my client. I have 4 copies of it.
Okay, I don't need to see them now, but arrangements can be made for them to be,
Yes, I just don't know whether Mr. Koko wants to refer
or
to the
wanted,
document.
yeah.
Yes,
For my purposes, what he has told
So
me is
it's
enough
just
now.
for, I wanted, they helped me with the dates.
Yeah,
So it's
okay.
between, we will come back to them.
Yeah.
At one point, you will have to see them, because one of the things that pains me is people coming to you to lie to you to make me look bad. And I will show you in those minutes
Yeah,
how that happens. But the date you are looking for, Chair, is between the 22nd of July
and the 1st of August.
and the 1st of August.
Yeah, okay, all right. Mr. Selega?
Yes, we'll return to that later then.
Okay, all right.
I think I
Yes.
will, let me just follow my sequence.
Yeah.
Mr. Koko, please turn to Eskom Bundle 14, bracket C, the one I sought to refer to just before the T adjournment.
877.
Yes.
Yes, but I did not get 877 point.
Point 82.1.
What is the page number?
877,
Yes, I'm there, Chair.
you're there. I'm sure you will recognize the document.
I do recognize the document, sir.
877, Chair, point 82.1.
Yes. 877.2.
82.1.
Well, I have 877, but I don't have point something. Is it bundle 15?
14, Chair, sorry, bundle 14, bracket C.
Okay, all
So
right.
we're moving to another bundle, I beg your pardon, Chair.
877.82.
182.1,
Yeah, okay.
acceptance letter on Eskom.
Oh, yeah.
Yes. Yes, so Mr. Koko, this is the letter, I think, signed by you. That's the letter you're referring to earlier.
That's correct.
Acceptance letter in respect of the corporate plan is dated 29 September 2015. And it's addressed to Dr. Alexander Wise and Vikas Sega, notification of acceptance for the provision of consulting services. We accept your proposal for the provision of consulting services on a fixed basis in accordance with the terms and conditions specified.
I'm sorry, Mr. Selega. Mr. Berry, I want to try and regularize properly what happens when you wish to say something, so that you don't just stand and start talking. Now, one way in which it could be done is that if you switch on your mic and I realize that it's red, I would know you would like to say something, then I would let you say so.
Are you able to see that if...
But, well, that's the point I'm raising, because where you are, I won't see it easily. I wonder whether it's possible for you to sit where I will see it easily.
Mr. Chairman, it's a question of the acoustics in this place. I have to sit here to be able to hear you.
Okay, all right. Okay, so if you are going to remain there, well, I'm trying to see whether if you were to be...
Because I misheard, for instance, when my learned friend refers to bundle
Yes.
16, I heard
Yeah.
bundle 14.
Okay, I think maybe what we do is...
But I will do whatever you want me to do. I'm
yeah,
gonna show
no,
you.
that's fine. Let's say you will stand up, but wait for me to say you can speak.
Very well.
Okay, all right. Thank you, Mr. Selega.
Thank you, Chair. And then the scope of work. Then you have a paragraph called contract, the heading contract. Below that is the terms and conditions of the NEC. Professional services contract will apply. Contract conditions, additional SD and L requirement, subcontracting of 30% of the contract value to a black-owned supplier will apply. Then you have the fees. Turn the page, please. There is a table of rates, and under that there's documentation, and it reads the contract documents will be available for your signature and acceptance within 1 week of receiving the notification of acceptance or within any longer period agreed between Eskom and McKinsey and Company. Then there's confirmation. We confirm that a contract will exist between Eskom and McKinsey and Company on the above basis. Please indicate your acknowledgement thereof by signing below and deliver to the undersigned. Now, I would like you to explain to the chairperson how should one understand this. On the first page, which refers to the terms and conditions of NEC, it says contract, terms and conditions of NEC professional services will apply. And on the next page, it says the contract documents will be available for your signature and acceptance within 1 week of receiving the notification of acceptance or within any longer period agreed. Could you explain to the chairperson how should this be understood in the light of the conclusion of the contract and the provisions that you refer to in that?
Excellent, Chair. And it ties back to the discussions that we had.
Yes, and I see that that last paragraph on confirmation speaks to what you were saying.
Yes.
Namely, a contract exists once there's been that acceptance.
Yes.
And the formal contract comes later.
Correct.
Yeah.
But the issue here, Chair, is that at this point, there cannot be uncertainty about the terms and conditions of the contract. There cannot be. So at this point, the terms and conditions of the contract are done. And in this case, we're using NEC contract, standard contract, no deviations from the standard contract. So everybody in Eskom, it's like a militarized environment. NEC conditions, you are not allowed to charge, cut and paste, that's what's going to work. Then the next question will be, are there any additional conditions that are authorized by the board? And the answer is yes. The additional conditions authorized by the board is a 30%, if you read it, subcontracting 30% of the contract value to a black-owned supplier will apply. That's authorized by the board. That's additional contract.
That's not in the normal
That's
conditions.
that's not in the normal issues. That is why it's written specifically. Then the next one is the fees. Now you see, and this is a difference between MSA and this one. The fees are National Treasury's fees, fixed, not risk-based. Now, the understanding in Eskom, Chair, is that once this letter is signed by both parties, it's binding. And soon thereafter, a contract will be signed. Now, yes, that's, so Eskom procedure is that if you want to do work before the contract is signed, the GM legal, the GM commercial must authorize you in writing. Right? So I have no doubt.
Yeah. No, I think that you have explained sufficiently. I think Mr. Selega must just be more specific in terms of what it is that he would like you to deal with.
And these letters are standard, Chair. And the fact that it says contract will, it's neither here nor there.
Yeah. Mr. Selega, do you want to be more specific as to what you wanted to explain?
Yes, correct, Chair. Chair, that procurement and supply management procedure, Mr. Koko was saying, it was saying if a contract, NEC has been used, then there are obligations of the procurement practitioner to ensure that the contract is completed, is correct and complete with all the drawings there. They use the drawings, and here the letter specifically says contract, and it says the terms and conditions of the NEC professional services contract will apply. So that's one. And if you turn the page, it says the contract documents will be available for your signature and acceptance. And it tells them within 1 week or within such longer period as the parties may agree. So I wanted you to explain to the chairperson, in the light of what is stated in this letter, when does the contract become concluded when you look at those provisions? And I want to read, just before you answer, that last sentence which the chairperson read. The last sentence, confirmation, says, we confirm that a contract will exist between Eskom and McKinsey on the above basis. Now, Chair, it doesn't say upon your acceptance, but it says on the above basis, which basis includes the documentation to be provided for signature and that the NEC professional services contract will apply.
Yeah, let me maybe ask these questions, and maybe the answers will automatically answer that, or we'll see if there's a need. Some of these questions, your counsel will be thinking, this is law, but we just want your understanding, because you obviously have been at Eskom for many years. You grew up there, so you know how things work. Is your understanding that when you send the notification of acceptance, the contract is concluded when the supplier receives that, full stop, or when the supplier receives that and signs it and sends it back to Eskom? Are you able to assist there in terms of at what point Eskom would regard the contract as having been concluded?
Chair, I can assist.
Yes.
I've seen many of these things.
Yes.
And part of what you will have to make, to determine is the practice and what you can read in the document. In Eskom terms, once a letter of award is signed, that's a contract.
That is signed by Eskom or by
No.
Eskom and the supplier?
Eskom and the supplier.
Okay, all right.
Once a letter of award is
Yes.
signed by both Eskom and supplier,
Yes.
it's a contract.
Yeah, okay.
What Eskom does not want, Chair, is that you start doing the work before the actual contract is signed.
Yeah.
Eskom frowns at that, it discourages that.
Yes.
But you can do that, and I imagine if
There are good reasons.
if there are good reasons to do that, and the GM procurement must
Authorizes,
authorize that.
Yeah. I hope that helps, but if it doesn't help, you can take from there. As I understand it, to the extent that the letter of acceptance, or maybe speaking about documents that on the face of it, the supplier maybe is still to receive, obviously the supplier must see those documents before it signs, because once it has signed, it will be taken to have seen them. That would be my understanding.
Yes, you mean once it signs the acceptance letter, Chair? Yeah.
That the acceptance letter.
Yeah, Chair, I don't think it's the case here.
Yes, okay.
You will
I mean, you can take it.
Yeah.
You can take it for. I'm just sharing with you.
Yes,
My
your
understanding of
understanding,
Mr.
yes.
Koko's
No,
evidence.
correct.
Yeah.
Because, Mr. Koko, you see on that understanding, your letter, you signed it on the 29th of September 2015. It was countersigned also on the same date, 29 September 2015. And on the face of it, I'm saying on the face of it, it envisages that a contract must be signed as the procurement policy contemplates, which is if you use a NEC contract, then the procurement practitioner must ensure that the documents are correct and complete, and there should be a signature of the agreement of the contract before services are rendered.
Chair.
But did you understand what I'm saying?
Yes, I did.
I'm saying on the face of it, it envisages the signing of the agreement.
Chair, the Eskom procurement manual is very clear. The letter of award is binding and the contract is always signed later. All
Yes.
Eskom letter of
But
award.
before you answer, Mr. Koko, just for me to understand the basis of Mr. Selega's question, what's the basis for that suggestion, Mr. Selega?
That the letter envisages the conclusion of an agreement, Chair.
Well, the letter may well envisage the conclusion of a contract because the formal contract would always, according to Mr. Koko, would always come later.
Yes.
But I understand you to be making a different point, namely, the contract must be signed before this acceptance is signed.
No.
Okay, what is the point?
Before the work is done.
Yeah, but that's the point he has made too, that
Yes.
before the work is done,
Yes.
the formal contract must be there.
Yes.
But there are circumstances where work can be done before the formal contract is concluded.
Yes.
But in that case, you need special authorization from somebody.
From GM Legal.
And process. That's his evidence.
Yes, okay. But then, if we take it further, then Mr. Koko, if we take it further, because this is another aspect, but let me take it further, Mr. Koko. The NEC was then exchanged between the parties, which is the next, it's on the next pages.
Yes.
And two things, because you will have to explain to the chairperson. Here we understand that work was done. Work was done prior to the NEC being signed. And you will have to explain to the chairperson, if that was so, whether there was a permission in writing for work to be done prior to the NEC being concluded. But then, if you go to the NEC, which is, if you go further to the NEC, you see there that the documentation is not fully completed, on the face of which a conclusion could be made that the NEC, if not fully completed, didn't come into existence. So, just explain the first one to the chairperson. If work was done without the contract being signed, was there a written permission to do so?
Yeah. So, Chair, I think we've leveled up on the process. Now it's about application. So there would be nothing untoward if the work is done without the contract signing for as long as it's authorized. There's nothing
By the right person.
by the right person. There's absolutely nothing wrong with that. And this is where my frustration is. If you follow the Eskom process, then you'll get to this point that says work was done, we needed a general manager sourcing to authorize it, and the general manager sourcing in this case happens to have been the project manager of this contract, Mr. Kavenda. So then your line of investigation is targeting the right people. Then you're going to go back and say, Mr. General Manager, procurement, who happens to be the procurement manager, there is evidence before us that the NEC contract was not concluded. In fact, the evidence before the commission is that it was signed much later. I want to deal with that too because it affects me. Did you authorize that the work gets done in writing, and where is it? Then you are talking to the right person. I am not in a position to assist you with that. But if you follow the Eskom process, you then will be able to hold the right person accountable.
But, Mr. Selega, where does it say, this is the terms and conditions of the NEC professional services contract will apply. You see, I take that to mean, I don't take that to necessarily mean the supplier must sign those terms. I take it to mean as long as the supplier knows that those are the terms, if he has signed or if it has signed the acceptance letter, that's in order. But it may well be that somewhere there is a document that says the NEC professional service contract must be signed, because this letter, notification of acceptance, doesn't say that the NEC professional service contract must be signed. It simply says its terms and conditions will apply. So for me, if the supplier is aware what those terms are, even if they have not signed, that's enough. But obviously, if there is a requirement somewhere that knowledge thereof is not enough, but you must sign, then that's a different matter.
No, Chair, you must read it with go to the next page, Chairperson.
Yes.
Under documentation. Because that too,
Yeah.
must be read with the policy Mr. Koko has referred us to.
The contract documents will be available for your signature and acceptance within 1 week of receiving the notification of acceptance or within any longer period. Yeah, well, contract documents, I guess, would include the NEC
Terms and
professional services contract.
For signing and acceptance.
But I don't know whether, I don't know how much point you want to make of it, but you must make whatever point you would like to make. Let me hear what Mr. Berry has to say.
Just having regard to the most basic principle of understanding and interpreting contractual documents, being that one reads the documents within context of the document as a whole, as well as the context of what would have been attendant upon the parties' intention at the time. What is relevant here is, Mr. Chairman, that indeed, as my learned friend pointed out, under documentation, it states the contract documents will be available for your signature and acceptance within a week of receiving the notification of acceptance. That acceptance, of course, is right at the very outset of this document. But what then further occurs is that on page 877.82.3, there is the following. We acknowledge receipt of your notification of acceptance dated 29, and this is now filled in by Dr. Weiss, confirming that the contract will exist between Eskom and McKinsey and Company from 1 October 2015 or soon thereafter. So that is now the acceptance of the contract. You'll find that on page 877.82.3. And then furthermore...
Yes, no, but Mr. Berry, you might be addressing a different point. I think my issue was simply whether it's necessary to sign the NEC professional services contract, but if Mr. Selega says it is and wants to pursue that, that's fine. I just wanted to say I wasn't sure that if the NEC professional services contract is not signed, but the letter of acceptance is signed, I wasn't sure that there would be no contract in that case. Yeah.
That is the issue that I'm addressing, because it is confirmation of what you put across.
Okay.
And in that regard, further, you will find, in other words, that document says that the contract will exist then from a certain date that is signed. And then, in fact...
Do you want to say where you're reading from so that...
I referred you to 2 pages further on than where you were, at page 877.82.3.
Yes.
You will find there an acknowledgement by Mr. Weiss, I think it's Dr. Weiss, on behalf of McKinsey, completed in his handwriting on the same day, 29 September 2015. Signature appears there. Are you there, sir?
Yeah, I'm there, yeah.
So that is then the concluding of the contract. And the documents that would be available for signature within a week, they are also here, and that you will find from the next page, page 877.82.4. And in fact, these documents were also signed on the same day by McKinsey.
Okay.
And that you will find on page 877.82.6, where Dr. Weiss's signature again appears, dated the 29th of September 2015.
Okay, all right. Mr. Slega?
Thank you, Chair. That NEC contract, to the extent that the letter refers to it, Chair, you will see the policy under that paragraph 3.4.8 has two paragraphs. One is that acceptance of the award or notification of award, and then you have a step dealing with the contract. And there, the step dealing with the contract specifically says, if a contract, bracket NEC, is used, then the procurement practitioner has the steps to do. But let's do this, Chair. Let me ask Mr. Koko this question, because in the second paragraph, signing of the contract is explicitly required in that policy. Let me ask then Mr. Koko this. Mr. Koko, if you're saying the letter of acceptance creates a contract between the parties, because the policy only says it is legally binding on Eskom. It doesn't say it creates the contract, because the contract is dealt with in the next paragraph. If that letter creates a contract, what is the need to send the NEC, which you say should be signed?
Chair, we're dealing with practice here, and I can't undo the practice. That's how Eskom worked
Yeah.
all along. That's how it worked. You sign the letter for what? The contract without fail gets signed later. In many cases, in a lot of cases, contracts don't get signed for years, actually. And
Which is wrong.
Eskom gets embarrassed afterwards. After Eskom gets embarrassed afterwards. But that is why the contract, the third paragraph I read, it's very clear. It's very clear. It says, first, the letter is binding and it creates a contract. And if you reach a different conclusion, you will create a revolution in Eskom. It's okay.
Well, no, I do want to ask Mr. Selega what it can mean if it says legally binding, if it doesn't mean a contract comes into being, so that I can understand his thinking.
Eskom is 90 years old. Binding in Eskom terms for Eskom practitioners, we've always understood it to be creating a contract.
Yeah. Okay. All right. You hear my question, Mr.
Yes,
Selega?
no, I heard your question.
So that I can follow if, because for me, coming from the general principle of that an offer and acceptance creates a contract, and then you have a situation where now an acceptance is contemplated and the document says it's legally binding. I can't think of any legal consequences other than contractual legal consequences.
Yes, Chair. When you read it in the context of the policy, where they say notification of an acceptance of the award will be legally binding on Eskom. So that means you have accepted, as Eskom, the offer made by the supplier. But the policy goes further, Chair. It doesn't stop there. It says, if an NEC agreement or contract is used, then ensure that it is signed. And it tells the procurement practitioner what to do. All the documentation must be in place. And if I may say, the law, the law says if the parties envisage a written contract to be in place, the contract doesn't come into place until it is signed. And that's the reason why I was asking Mr. Koko. If they contemplated the NEC terms will apply, the next page is saying the documentation, the contract documentation will be given to you for signing and acceptance. Why did they send the NEC to the supplier if it is sufficient to simply have a letter of acceptance, which created the contract? But he has answered that.
Yes, because the letter of acceptance says the terms in the NEC will apply.
Yes.
Therefore, before the supplier signs, the supplier must satisfy itself that it is happy with the terms and conditions of the NEC because they will apply. But if the supplier chooses not to wait for the terms and conditions of the NEC before it signs the acceptance letter, it seems to me that once they have signed, they are deemed to know those terms and they can't complain. And on the face of it, that's what seems to be the position as I see it. But what I'm saying is, if you have a different understanding, I'm not saying don't pursue it, but I want you to have the benefit of what I make of it.
Yeah. I think Chair and I are slightly on different points.
Yes.
Yeah,
So
I think
is
we are slightly
your
on
point,
different points.
is your understanding, just articulate your understanding in terms of the substance of what all of this means.
Yes, Chair, because my, what I'm putting to Mr. Koko arises even from the policy itself, one, and then from their own practice, which is what Mr. Koko is referring to, two. One is, they've done the first step in terms of the policy. They exchanged the letter of award, or the letter of acceptance.
Yeah.
Yes. Number two is the next step in the policy, which they also do, which is to exchange the NEC for signing and acceptance. Now, my question to him is, if the letter of acceptance creates a binding agreement, what is the need for the second step, which the policy contemplates, which is also executed by them, by him in this case?
But is there something that says the NEC document must be sent to the supplier after the supplier has signed the acceptance letter?
Yes, and that's where I think, Chair,
Yes.
yeah.
On your understanding?
No.
It
No,
doesn't.
it's
Because
not.
if it doesn't, if your understanding, if it's not your understanding that the NEC documents must be sent to the supplier after they have signed the letter of acceptance, and if your understanding is that is to be sent before or at the same time as the acceptance letter, I don't see a problem. But I would see a problem, I would see your problem if you say the policy and the documents contemplate that the sending of the NEC document should happen after the supplier has signed the acceptance letter.
Well, when you read the policy, Chair, and when you look at the steps taken, because this is, I think Mr. Koko's letter is in accordance with that policy. So the acceptance between the offer.
Let's read the policy, just read the relevant
read it?
policy so that we don't speculate about what it says.
Yes. It says, first is notification of award. So once approval has been given to the award of the contract to the successful supplier, the procurement practitioner notifies the supplier of the acceptance of his tender. The procurement practitioner must ensure that this notification is received by the successful supplier, because notification of acceptance will become legally binding upon Eskom. Emailed notification will be subject to electronic the Act, the Electronic Communications and Transitions Act. That's point one. So they do the acceptance. Here is, we accept your award, and they would sign, my understanding is they would then sign that acceptance letter, both Eskom and the supplier. Then you have point two.
Well, why do, obviously, Eskom would have signed the letter of acceptance before it sends it to the supplier.
Correct, yeah.
But why do you say that before there is step two, the supplier would have signed? What's the basis for saying that?
Well, I'm not necessarily saying that's
Step one might consist of only Eskom sending the notification
Yes.
without necessarily the supplier signing as
Yes.
yet, isn't it?
Yes.
Yes, that's
Yes.
one scenario. You
Yes.
accept that. Okay, then what is
Yes.
supposed to come after that?
Then two is compiling the order/contract. It says the procurement officer responsible for the compilation, administration, and finalization of the contract/order. If a contract, bracket NEC/FIDIC, bracket has been used, the procurement practitioner, together with the cross-functional team, ensures that the contract documents are correct and complete with all drawings and specifications and included as part of the contract. And the procurement practitioner arranges for the printing of the contract for purposes of signature. And then you have step three, which is signing their contract.
Let's talk about step two.
Yes.
On my understanding, there is nothing inconsistent with Mr. Koko's evidence about step two.
Yes.
Yeah, okay.
Yes.
Let's go to step three.
But you will see the point I'm trying for Mr. Koko to explain is, if step one creates a contract, what is the need for step two?
Hang on.
Yes.
If, remember that on your approach, step one consists of the sending of the notification.
Yes.
Now, Mr. Koko, as I understand his evidence, didn't say that upon the sending of the notification, a contract is created. He said the supplier must sign.
Well, he was reading that legally binding, Chair, from step one.
Well, it was clarified. You remember I asked him a question later on.
Yes.
And he said it's got to be signed by the supplier. Mr. Koko, am I putting
That's
words in your
correct.
mouth?
Yes.
So his evidence is the contract will come into being will not come into being before the supplier signs.
Yes.
I mean, I didn't take it a step further, which might be legal, whether after the supplier has signed, the fact of the signature that they have signed must come to the attention of Eskom. You know, that's, I thought it's enough for his purposes that he has said the contract will come into being after the supplier has signed. So, and that part, the signature of the supplier, need not be on the same day as when Eskom signs the acceptance letter.
Yes.
But it could be.
Yes.
But it could be a day later, it could be a week later, or whatever.
Yes.
Yeah.
Let's accept that, Chair. Let's accept that. The question is, the signing of the contract is envisaged in the policy. Not only in the policy, in the policy, and hence, I think, they may have done so in this letter, Mr. Koko saying, we will send the documentation to you for signing and acceptance. And I think that's where my question lies, which is, if then we accept the notification is out and it has been accepted, because step 3 here is signing the contract in terms of the policy, which is also what is envisaged in the letter. Why do we need that if the acceptance...
Why do you need what?
Why do we need the signing of the contract when the letter, once signed by the supplier, creates the contract?
Well, you remember, I think I said to him, it may well be that for purposes of having all terms and conditions in one document, that might be necessary convenience. That's what I said. Mr. Koko, you may have dealt with this, but you want to respond to that. The question is, if there is already a contract after the supplier has signed the letter of acceptance, why is there need for a contract to be concluded later?
Chairman, I've got two answers to that. Besides telling you that it's precedent and it's a culture, we found it working that way. But in my day-to-day life, I found a signed contract that clarifies a lot of issues. I've always been better off
with a contract.
With a contract than with a letter of award.
Then different pieces of
and
documents.
Different pieces. It takes away gray areas. But Chair, I need to say the second thing, that the 321034 contemplates any form of contract. It's got it. I think we are overemphasizing NEC, whether it's FEDIC or NEC or bespoke. The design of the 1032 document is that once there's a letter of award, the procurement practitioner must put together contract documents, and it is his or her responsibility to make sure that it is signed by a person who is duly delegated by the Board and Tender Committee. So whether it's NEC or not, it's irrelevant. Whether it's FEDIC, is irrelevant. Whether it's bespoke, is irrelevant. But all put together, they must be in place and be signed by a person who is duly authorized by the Board Tender Committee, and it's a responsibility of the procurement practitioner that he or she does that it happens.
Mr. Silaga.
Yeah, thank you, Chair. Chair, if the offer and acceptance stage creates a legally binding agreement on the face of that very letter with minimal details, can you imagine SOEs contracting on millions like they did the 101 million on the basis of that letter?
Well, you see, Mr. Silaga, as far as the law is concerned, we all know the general principle that if there is an offer and an acceptance as a general principle, there is a contract. Okay? Obviously, the offer and acceptance must include all the necessary terms and conditions. If they are not included, then it's not a valid contract.
And in this case, they were included.
So that's the general principle of law. Now, of course, it is possible that in a certain sector or scenario, there could be legislation or there could be a policy of an entity that says, until there is a formal contract signed, nothing is binding that the parties may have exchanged, But if you don't have anything either by way of legislation or by way of the regulations and rules or policies of an entity that deviate from that general principle, one would expect that that general principle would apply as long as all those terms and conditions are there. But if Eskom has, maybe there is legislation that says, well, when you deal with Eskom, you won't have a contract just because of exchanges of emails and whatever and discussions, there must be a formal contract, then that's different. So as I understand it, in this case, nobody has said to me that there was such legislation or rules or regulations, but you have made a certain point with regard to the policy, but I don't know whether you go that far.
Yes, Chair, can I say this? Because and maybe that will close it on that.
Yeah.
The offer and acceptance principle doesn't stop there, Chair. If the parties envisage that they should sign a contract, which is what is contemplated contemplated in that letter, then the contract comes into existence as contemplated by the parties upon them signing it.
No,
and that's to the extent I'm taking.
I think that's in order as a principle to say,
Yes.
if the parties say for a certain period we'll be negotiating,
Yes.
and during the negotiation certain things might be said to each other, but we don't want to argue about whether while the one party thought we were still negotiating, the other one thought we already had a contract.
Yeah.
Therefore, there will be no contract until there is a formal contract. That position can apply. So if you say this is what you believe is the position here, then it's a question of going to the basis for that, and then you can put it.
Yes, I think Mr. Cook, I think I've travestied with you, because from the policy, I see the policy being staggered in terms of process. One of notification of award, the next is what the practitioner should do in terms of preparing the documentation for the contract, and the third step is the signing of the contract itself. And I see your letter being consistent with that process.
Chairman, I have said my say. I can't take this further. A letter
Yes.
of award and acceptance
Yeah.
in Eskom terms is legally binding. Put a contract in place. That's a practice. But let me say another issue, Chair. I appreciate the risk that is raised by Mr. Seleka that
About SMMEs.
not about SMM, it's about doing the work without a contract with a letter of award.
Yeah.
And the policy is very clear as well. If you read it, it's very clear. It says it does not it does not take kindly to work starting without a signed contract. It's very clear. But it does say also there are circumstances that may
Which may render it acceptable.
that may render
That be done.
except that it be done.
Yeah.
And what I'm trying to put it to you is that, and I'm not saying so, I'm saying there may well have been, but if there
Such a case.
there may have been such a case,
Yeah.
and if you are not targeting, if you are not on a Koko hunt, you may get to a decent answer to that. And if there is no decent answer to that, then you are zooming into the right person. I'm simply asking you, Chair, stop the Koko hunt.
I'm not doing a cocoa,
The people here must, but
Mr.
they
Koko,
follow the procedures.
you did say you can't help with the question of whether work was or wasn't done before the contract was concluded.
Correct.
Yes, and you did say the person who would know about that, I think is Mr. Govender, is that?
Correct.
And whether or not, if work was done before the contract was concluded, whether the requirements of the policy for that to happen were met.
Correct.
Would be him.
Correct. What I need to help you with, Chair, and here it's again following the process. When Mr. Singh was here previously, it was put to him that this contract we're looking at, was actually signed by Mr. Mabilane and not by Mr. Koko, who was delegated. This question arises again in the High Court. Eskom makes a case that says we can't find a delegation of authority that Mr. Mabilani relied on to sign this contract, because the delegation was to Mr. Koko. I have a duty to assist you there.
May I assist you?
And if I can, I will do that now.
Yeah. Yes, may I assist, because
Yeah.
I didn't ask the question why Mr. Mabelane signed. That was a piggyback from Mr. Singh's answer that he doesn't know why Mr. Mabelane signed, because the delegation was given to Mr. Koko. And then I said to him, oh, but does it mean Mr. Mabelane then didn't have authority to sign? In which event, even if he had signed properly, the contract would not have come into existence. Then he said, no. He can't recall whether the delegation was given to the person or to the position. Yes. So I didn't put. Mr. Koko is burning to deal with that question.
Yeah.
But I've seen that point.
Yeah.
And I have to, Chair, because the following day, the headlines were, Mr. Singh throws Mr. Koko under the bus because Mr. Koko did not sign as authorized.
Yeah.
So my name has been dragged in the mud. I have to correct it, Chair.
No,
It's
no,
a
that's
personal
fine.
issue.
But
It
that was not
affects
my
my 5-year-old. My 5-year-old comes to me with a newspaper clip. Daddy, what's going on here? So I have to correct that.
No, that's fine. Mr. Seleka?
No, that's fine. And you know then, Mr. Koko, just to close off on this, that we have put to Mr. Singh something that we can also put to you, that the NEC contract that was contemplated to be signed was in fact not signed properly by Mr. Mabelane. You are aware of that?
Chair, and this is what I want to be allowed to deal with, Chair. So I am going to give you a set of a document that answers that. I have to.
Yeah.
I
I'm
have to
sorry, I
do it
didn't
now.
hear the
Just
question.
tell
What
us.
is the question?
What I'm putting to him, Chair, is that the NEC contract that was envisaged to be signed, it's in the bundles, also in Mr. Singh's bundle, is not signed properly or completely by Mr. Mabelane.
Yes.
Yes.
So were you asking him whether he was aware
Whether
of
he
that
was
or
aware of
not?
that, yes.
And he would like to deal with that?
Yes, I want to deal with that. And
Okay, all
my
right.
straight answer to you,
Yeah.
and I will answer you straight, and I will show you the documents. I don't know. I did not know. I couldn't have known. I was not in a position to know.
Okay.
Then that's fine.
No, but I want to show you the documents, because this question is going to come back again when we deal with Ms. Mutepu's argument.
Let's
I want to deal with
let
it
him
now.
refer to the documents.
Do you want
Mr.
to go to the document?
Yes, I want to do that.
The NEC,
No. Last night,
The document signed by Mr.
yes.
Mabelane, that's the one you are looking for.
No, I have it. I'm just removing. I'm just
Okay.
removing this file.
Tell us once you know which bundle we must look
Yeah,
at.
it's not in the bundle. It's not in the bundle.
Yeah,
But after Mr. Singh's statement,
Yeah.
I went to dig. But I've got the documents here.
oh, they are not part of the bundle?
Yes.
Okay, why don't we do it this way, because we are close to lunchtime? Why don't you share the documents with Mr. Seleka, and I can be given those, and then when we come back, you can deal with it.
Thank you, sir.
Yeah, let's
Chair,
do it
maybe
that way.
the witness must first just specify what document he's referring to, because I believe that it might be in the.
No,
Yes.
Mr. Barry, you don't have it because I picked it up last night. It's not in our bundle, so
Okay.
I know.
Okay, all right. All right, let's well, we are at 10 to, but when he deals with them, it's better that I have a copy and you have a copy. We can do one of two things, because there's still 10 minutes. Mr. Koko, you can deal with this issue when we come back.
Yes.
But if Mr. Seleka can use the next 10 minutes to ask other questions, let's do that.
Can I do that? Right. Chair, Mr. Koko, I want us to go back to those emails, bundle 18, Eskom bundle 18. And, yeah. Eskom bundle 18, page 1018,
My apologies, Mr. Smith.
bracket B. That's the one we were using, we started off with this morning.
Yes, I must find it.
Yeah.
I've got it, Chair.
You've got it, thanks. And Mr. Cook, I want to expedite the issue of the emails. You mentioned, yes, because we gave you Dr. Ngubani's affidavit, you mentioned that affidavit. Before I get to the affidavit, you have said every time you exchange these emails with Info Portal, you would have a meeting with Dr. Ngubani and Ms. Daniels. Correct?
That's correct, Chair.
Yeah. The email regarding the visas.
I'm sorry, can I just check this? When you received an email from Info Portal, would you have a meeting with the two, or would you only have a meeting with them if or when you had sent something to Info Portal, or both?
Chairman, what I would normally do, I will have a discussion with Ms. Daniels, and I will tell her what is coming. And then I will send the documents. Then she will arrange a meeting, and then she will print the documents. And then we'll have a discussions with Dr. Ngubani.
Yes, but what I'm asking is whether you are saying, irrespective of whether you would have sent a document to Info Portal or whether you would have received a document from Info Portal in an email, there would be such a meeting, or whether you are saying there would only be such a meeting if you had sent or were about to send.
Chairman, I have received one or two emails from Info Portal address.
Yes, yes. Most of the time you sent.
Most of the time I send.
Yes.
And the first one that I received, I was in Indonesia, and I was not even aware that it came from Info. Yeah, that was a visa one. The second one is the one I forwarded to Ms. Daniels on the 10th of December 2015,
Okay.
which I also followed
Yes.
up with her to say, do we need a meeting? And he says, no, we don't need a meeting. We have it. She's got it under control. So most of the time is when I send.
Yeah.
When I have a consistent to the briefing that I got when I first came back, that when you have an issue that you think that you are not seeing eye to eye with the chair or with the board, make it available to the chair, and let's discuss it before the board really meets and deals with it, and you clear the air on that.
Okay.
Please turn to page 1078. 1078. Yeah, there. Right. Yes. So this is, again, an email from you, Wednesday, 30 September 2015, to Info Portal. And it says, attached to this is this letter on the next page, yes, which is Dr. Ngubani's letter to Minister Brown.
Yes.
So why, on your version of this being Dr. Ngubani's email address, why would you send his letter to himself?
Yeah. So Chair, this is the more. What's the right? I must choose the right word. This was the most horrendous letter. That was.
I choose a very strong word.
That I could have chosen the worst word.
Okay.
That Ms. Daniels made available to me to implement. I was at that point the Chief Procurement Officer for Eskom. The board of Eskom irregularly and unlawfully takes a decision to boycott Mail and Guardian, City Press, and Sunday Times for whatever reason. And then it comes to me to implement. It's an unlawful instruction, Chair. I can't implement it. And it was never implemented. And again, we discussed it with Dr. Ngubane, we discussed it with Ms. Daniels. And it was never implemented and I was never in trouble. If I decided not to send it back to Mr. Ngubane for discussion, and I did not implement it, I would have ended up, same way I've ended up with Mr. Tsotsi.
Now, just for the sake of completeness, the attachment to the email that Mr. Selega is asking you about is a letter signed by Dr. Ngubane on the 30th September 2015, and it is addressed to the Minister of Public Enterprises, Ms. Lynn Brown, and says, "Dear Minister Brown," and the subject is suspension of contact in any form whatsoever and or commercial relationship with the Mail and Guardian, City Press, and Sunday Times. And the letter reads, "The above matter has reference and minister's correspondence of 28 September 2015. The board has deliberated on the issues and found that Eskom is experiencing a similar trend as the Transnet example. Accordingly, the board has resolved that, as quote, Eskom shall suspend any dealings, be it the placement of advertising or any other commercial relationship with the Mail and Guardian, Sunday Times, and City Press, pending the resolution of the complaints that the state-owned entities have against the three newspapers," close quote. Mr. Anuj Singh has abstained due to a conflict of interest as he was the subject of one of the articles published. This decision has been communicated to the Group Chief Executive to implement with immediate effect. I trust that the Minister will find this in order. Yes, that's the, are you therefore saying that this letter, which seems to have been sent to the Minister, was given to you for purposes of implementing the
Correct.
resolution?
Correct.
And you believe that the instruction was unlawful, and you then wanted to discuss it with Dr. Ngubane?
Chairman, I don't believe it's an unlawful instruction.
Yes. But you then wanted to discuss it with Dr. Ngubane?
Correct.
Yes. You say that's your explanation for your email at page 1078.
Correct.
Yes. Mr. Selega?
Thank you, Chair. Well, that paragraph, Mr. Koko, says the decision has been communicated to the Group Chief Executive. Were you the Group Chief Executive in September 2015?
No.
So why are you placing yourself in the Koko hand?
Because I am the Group Commercial Officer. I'm the Chief Procurement Officer. The Chief Executive does not execute a procurement decision. The delegations for procurement is with me. It's with my office.
So to the extent that the letter or the resolution of the board, according to this letter, said that the group, or not the resolution, but the letter, to the extent that it said the decision had been communicated to the group chief executive to implement with immediate effect, the point you are making is that the GCEO would actually, in order to ensure that the decision was implemented, would require you to implement it.
Exactly.
And you were raising the issue because in the end you were going to be the implementer. let's take the lunch break. We'll resume at 2. We adjourn.
Thank you, Chair.